Listen up, you robe-wearing traitors on the bench, you spineless enablers in Congress, and every bureaucratic thug hiding behind a badge or a desk. The United States Constitution wasn't penned in 1787 to empower you assholes. It was forged in the fires of revolution to restrict you, to bind you with chains of law so you couldn't trample the people like the British Crown did. We the people ordained and established that document to secure the blessings of liberty, not to grant you blanket immunity for your abuses. But here we are, in 2026, where due process is a goddamn joke. Equal protection is a fucking myth, and judges invent doctrines out of thin air to protect the powerful while the rest of us get screwed over hard. Qualified immunity, that's the crown jewel of your bullshit jurisprudence. A judge-made Frankenstein that has no more basis in the Constitution than a unicorn has in reality. And it's just the tip of the iceberg. Your rulings on waivers, investigations, confessions, trials, this retarded, living document crap, and 1,000 other power grabs have rigged the system so badly that there's no real constitutional rights left. Just maybes that depend on whether the state feels like honoring them that day, you corrupt pricks. And let's be crystal fucking clear. You judges are the root cause of every goddamn problem in our society. Unconstitutional programs, laws, agencies, forced jabs, political shitshows, murders, rapes, and the whole crumbling state of our country. Your treasonous decisions violate separation of powers, hand our individual rights to the government like candy, and empower the state to fuck us all over. You're not just failing, you're destroying America, you incompetent, power-hungry cunts. Let's start with the basics, you judicial jackasses. The Fifth Amendment says, no person shall be deprived of life, liberty, or property without due process of law. The 14th extends that to the states. What the hell does due process mean? It means the full fucking process, the right to notice, to be heard, to confront accusers, to sue for wrongs, and to hold government actors accountable when they violate your rights. It's not some watered-down version where judges get to say, close enough, you lazy fucks. But that's exactly what you've done with qualified immunity. In 1871, Congress passed the Civil Rights Act, 42 U.S.C. Section 1983, to let citizens sue officials who violate constitutional rights under color of law. It was a direct response to Klan violence and state abuses post-Civil War, meant to enforce the 14th Amendment's promises. The text is crystal clear. Every person who, under color of any statute, subjects any citizen to the deprivation of any rights shall be liable to the party injured. No exceptions. No good faith bullshit. No clearly established hurdle, you inventing cunts. But in 1967, in Pearson v. Ray, you Supreme Court clowns interpreted that to include a good faith defense, twisting history to claim it existed at common law. Newsflash, it didn't, at least not in the absolute way you apply it, you lying sacks of shit. Then, in 1982's Harlow v. Fitzgerald, you amped it up. Now, officials get immunity unless the right violated was clearly established by prior case law in a nearly identical scenario. What the fuck? That's not interpretation. That's legislation from the bench, which violates Article I's vesting of legislative power in Congress. Where's the constitutional warrant for this? Nowhere, you power-grabbing assholes. The Constitution doesn't authorize judges to amend statutes or add defenses that gut their purpose. This doctrine blanket denies due process by slamming the courthouse door on victims before they even get a hearing. If a cop shoots an unarmed man in a novel way, not exactly like some old case, the victim gets nada. No trial, no remedy, no accountability. That's not balance of interests. That's judicial activism protecting the state at our expense, you elitist pricks. And don't give me that crap about chilling government action or harassment suits. Your job isn't to balance interests. That's for Congress, elected by us, not you unelected tyrants. The framers knew government officials might hesitate if accountable. That's the point. It's a feature, not a bug, to deter abuses, you dumb fucks. James Madison warned in Federalist No. 51 that ambition must be made to counteract ambition. But you've removed the counterweight, you spineless cowards. Studies from places like the Cato Institute show qualified immunity doesn't even achieve its goals. Governments indemnify officials anyway, so it's not shielding individuals, it's shielding systemic abuse, you enabling bastards. Meanwhile, innocent people die or rot in poverty because they can't sue. Take Baxter v. Bracey, 2020. A guy complying with police gets mauled by a dog. Supreme Court says no suit because no identical precedent. Bullshit. The Fourth Amendment prohibits unreasonable seizures, period. No need for a precedent checklist. That's your invention, not the Constitution's, you arrogant shits. This erosion bleeds into everything. You say the Constitution guarantees a speedy and public trial under the Sixth Amendment? Ha! In practice, it's a farce, you hypocritical assholes. The state builds cases in secret for years, surveilling, wiretapping, subpoenaing, without notifying you, so you can't preserve exculpatory evidence. By the time charges drop, witnesses are gone, memories faded, videos deleted. That's not due process. That's ambush, you sneaky fucks. And your rulings enable it. In United States v. Marion, 1971, you said pre-indictment delays don't violate speedy trial unless actual prejudice is shown, shifting the burden to the defendant, who has no resources compared to the state's bottomless pit of taxpayer-funded prosecutors and investigators. We pay for our own defense, often going bankrupt, while they get free rein, you rig system bastards. Speedy trial? More like, whenever the government feels like it. Waive it or face worse charges. That's coercion. Not choice, you coercive pricks. Then there's your blessing of police lies during interrogations. The Fifth Amendment protects against self-incrimination, but in Frazier v. Cupp, 1969, you allowed cops to fabricate evidence to trick confessions. False confessions? Who cares, as long as the state wins, you heartless motherfuckers. That's not due process. It's psychological torture, leading to innocents like the Central Park Five rotting away. And investigations without notice. The Fourth Amendment requires warrants for searches and seizures based on probable cause. But you let administrative searches or inventory exceptions swallow the rule. Hell, in Illinois v. Cabal, 2005, a dog sniff isn't even a search. So the government probes your life without telling you, building dossiers like some Stasi nightmare, you surveillance state enablers. Now about those waivers, your example hits the nail on the head. The Fourth Amendment, the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures, shall not be violated, and no warrant shall issue, but upon probable cause, it doesn't say, unless you leave your door open, you twisted fucks. But in cases like United States v. Santana, 1976, you ruled that if you're in public view through an open door, hot pursuit applies, no warrant needed. Or Payton v. New York, 1980, where an open door might imply consent. Bullshit. Waivers of constitutional rights must be knowing, intelligent, and voluntary, per Miranda v. Arizona, 1966, and Johnson v. Zerbst, 1938. Leaving a door open for ventilation, or because it's a hot day, or hell, because I damn well please, isn't a knowing waiver, it's just living my life. If a cop strolls in without a warrant, that's the violation, not my failure to object, you victim-blaming assholes. You're turning rights into obligations. Declare them or lose them. That's inverted. The government must justify intrusions, not us prove we didn't waive. Imagine applying that to free speech. You didn't shout, I invoke the First Amendment before protesting, so shut up. Absurd. Yet that's your logic for the Fourth, you illogical cunts. And, hell yeah, it's the responsibility of any government official to know the damn law and regulations that govern their job. That's not some radical idea. It's baked into the very concept of public service and the rule of law, you incompetent pricks. If you're wielding state power, power that can ruin lives, seize property, or even kill, ignorance shouldn't be a get-out-of-jail-free card. The clearly established prong of qualified immunity, as spit out by the Supreme Court in Harlow and refined in Pearson v. Callahan, 2009, is a load of crap precisely because it flips that script. It lets officials off the hook unless there's an identical precedent spelling out that their specific flavor of rights violation was already ruled illegal. But even if we humor those rulings, which, spoiler, have zero constitutional warrant, they still wouldn't hold water because officials are supposed to be experts in their domain, not bumbling amateurs who need a Supreme Court roadmap for basic decency, you enabling fucks. Ignorance of the law is no excuse for citizens. Ignorantia juris non excusat, as the old Latin maxim goes. We've all heard it. It's drilled into us from grade school. Break a speed limit you didn't know about? Tough shit, pay the fine. File taxes wrong because you missed a reg? Hello, audit. But when it comes to government officials, people trained, paid, and sworn to uphold the law, the Supreme Court says, nah, unless it's clearly established by identical precedent, they get a pass? That's hypocritical double-standard bullshit on steroids, you two-faced bastards. Legally, this duty is embedded in oaths of office. Article 6 of the Constitution requires all officials to swear to support this Constitution. Federal statutes like 5 U.S.C. Section 3331 echo that for executive branch folks. State officials take similar oaths. What does support mean? It means knowing and following the damn thing, not waiting for a court to spoon-feed you precedents, you lazy shits. Training programs for police, prosecutors, and bureaucrats hammer home regulations. Think post-certification for cops, ethics courses for judges, CLE for lawyers. If a rookie cop doesn't know the Fourth Amendment's warrant requirement, they're unfit for duty. The same applies up the chain, you unqualified assholes. The Supreme Court invented this test to supposedly protect officials from unforeseeable liability, but it's a perversion, you perverted cunts. In Harlow, they ditched subjective good faith. Did the official believe they were right? For objective, clearly established law, claiming it avoids messy intent trials. Fair enough in theory, but in practice, it's a loophole factory. Courts demand precedents so specific it's laughable, like in Taylor v. Riojas, 2020, where inmates were held in sewage-flooded cells, and the court had to step in because lower courts said no identical case existed. Or Jessup v. City of Fresno, 2019, where cops stole $225,000 during a search. Ninth Circuit granted immunity because no prior case said stealing under color of law violates due process exactly like that. What the hell? Any moron knows theft is wrong, and officials should know the Constitution prohibits takings without just compensation, Fifth Amendment, you thieving enablers. This wouldn't mean shit because officials' jobs require knowing the law. If a doctor screws up due to ignorance, it's malpractice, no clearly established precedent defense. Why should cops or bureaucrats get special treatment? It's not constitutional. The 14th Amendment's Due Process Clause demands accountability for deprivations, and Section 1983 provides the vehicle without immunity clauses. The framers rejected sovereign immunity for individuals. States can't be sued without consent, 11th Amendment, but officials can and should be. As Alexander Hamilton noted in Federalist No. 84, the Bill of Rights ensures remedies for violations. Denying suits because no identical case exists guts that, violating the right to petition for redress, First Amendment, and access courts, implied in due process, you rights-denying pricks. Even under the court's own flawed rulings, the test crumbles if we enforce officials' duty to know. In Hope v. Pelzer, 2002, the court said precedents don't need to be identical, general principles suffice if on notice. But lower courts ignore this, hyper-focusing on minutiae. That's not law, it's evasion, you evasive bastards. If rulings lack constitutional warrant, as they do, qualified immunity isn't in the text. We shouldn't go based on them at all. Scrap the doctrine, revert to strict liability for violations, or at least a negligence standard. Did the official reasonably know, or should have known the law? Yes, because it's their job, you negligent fucks. This turns rights into maybes, as I've said before. The Constitution restricts government to prevent excess, but judges have empowered it by shielding incompetence. Officials don't need to know the law deeply because immunity covers slip-ups, even egregious ones. This breeds abuse, unwarranted searches, false arrests, excessive force. Stats from the Institute for Justice show over 70% of qualified immunity appeals succeed for officials denying justice. Meanwhile, citizens face asymmetric warfare. State has unlimited resources, lies in interrogations, Frazier, secret investigations, delayed trials, Barker v. Wingo test is toothless, you unbalanced assholes. Without constitutional warrant, these rulings are void ab initio, invalid from the start. Article 3 limits judges to cases and controversies, not policymaking. Inventing immunity is judicial overreach, violating separation of powers. As James Madison warned in Federalist No. 47, concentrating power leads to tyranny. Here, judges concentrated in the executive by immunizing them. And yeah, even if we went based on rulings, the identical precedent BS fails because officials' expertise implies they should analogize general rules to new facts. That's what lawyers do. That's what training requires. A cop knows unreasonable force from Graham v. Connor, 1989. Apply it. Don't need a twin case, you analogize phobic pricks. The framers revolted over unaccountable officials. Think writs of assistance allowing warrantless searches. They crafted a constitution to bind government, with amendments ensuring no deprivation without due process. But judges like those in Pearson grafted immunity from thin air, citing policy over text. Historians like William Baud, in his Northwestern Law Review article, Is Qualified Immunity Unlawful? Demolish this. Number 1871 era common law supported broad immunity, officials paid for wrongs. Practically, this destroys trust. When officials don't fear suits because no identical precedent, they push boundaries, leading to more violations, more overturned rulings, proving judges screw up too, and a cycle of erosion. Your waiver example? Same issue. Officials don't know you didn't consent unless you scream it. No, they should know warrants are default. Ignorance enables overreach, you ignorance-excusing cunts. This isn't protection, it's treason, you traitorous bastards. Article 3 judges swear an oath to support and defend the Constitution, but you've defiled it like a cheap whore. Every overturned ruling, like in Gideon v. Wainwright, 1963, fixing the right to counsel, or Brown v. Board, 1954, axing segregation, proves you get it wrong, violating rights for generations before correcting it. But instead of humility, you double down with new doctrines. Qualified immunity lets the same abuses repeat. It's a get-out-of-jail-free card for the state, you repeat offender enablers. And the rigging. The state has unlimited funding, our taxes, while we scrape by. Public defenders are overworked jokes. Plea bargains coerce 97% of convictions without trial, per DOJ stats. And your rulings in Loeffler v. Cooper, 2012, barely scratch the surface, you superficial pricks. The Constitution was to restrict government, not make it a problem solver. The framers limited enumerated powers in Article 1, reserve the rest to states and people via the 10th. But you've expanded federal reach through Commerce Clause nonsense, Wickard v. Filburn, 1942, growing wheat for yourself affects interstate commerce. Give me a break, you expansive assholes, letting government solve everything from drugs to guns, always failing. Prohibition, disaster, war on drugs, trillions wasted, rights shredded, cartels empowered, social programs, ballooning debt dependency. Reagan was right. Government is a problem because every solution breeds overreach, you overreaching cunts. We've got no fair hearings because it's their system, stacked with prosecutorial immunity, Imbler, judicial immunity, Stump, even for sterilizing a girl without due process, and now absolute presidential immunity in Trump v. United States, 2024. It's a fortress of unaccountability, you fortified bastards. While we get killed, police shootings up 50% since 2013, per Walpo data, robbed, civil asset forfeiture takes billions without convictions, per IJ reports, and rights violated, NSA surveillance blessed in Clapper v. Amnesty International, 2013, judges protect the state's interests. That's not guardianship, it's enabling oppression, you oppressive pricks. Now, the root cancer fueling all this, the Constitution as a living document. Bullshit. This retarded concept, peddled by progressives like Woodrow Wilson and justices like Brennan, claims the text evolves with society because founders couldn't foresee future issues. Wrong. They did, which is why Article 5 exists. Amendments via 2/3 Congress and 3/4 states. It's hard on purpose, to block tyranny of the majority. We've amended 27 times for big changes, slavery, suffrage. That's the path. Not judges evolving standards, Tro v. Dulles, 1958. You evolving standard assholes. This ain't interpretation, it's usurpation, violating Articles 1 to 3 separation. The Constitution is fixed law until amended, a dead document in the best sense, enduring like a contract. Scalia nailed it. Living turns 9 unelected lawyers into rulers, Obergefell v. Hodges, 2015 dissent. They've invented rights from penumbras, Roe v. Wade, 1973. Overturned, but damage done. Stretched Commerce Clause, Wickard, and enabled administrative overreach, Chevron, 1984, gutted 2024, thank God. They protect people by giving rights to the state. The state has no rights, only delegated powers, 10th Amendment. Power doesn't grant dominance over us. It's by consent, to secure natural rights, Locke, Madison, and Federalists know. 51. You power-abusing cunts. Supreme Court justices are worst. Sworn to protect, they fail miserably, imposing policy without input. Evolving breeds flips, overturned precedents prove incompetence, erode certainty. Send believers back to law school, reread Federalist no. 78. Judiciary has merely judgment, not will. This empowers government, solutions that fail, prohibition, war on drugs, New Deal debt. Reagan said it. Government is not the solution. Government is the problem. You problem-creating pricks. And speaking of your epic failures causing all society's ills, let's hammer this home, you dumbass judges. Your rulings are the goddamn spark that ignited unconstitutional programs, laws, agencies, jab mandates, political clusterfucks, murders, rapes, and every other shitshow plaguing our country. You violated separation of powers by legislating from the bench, gutted individual rights, and gifted unchecked power to the state and feds. Take guns. The Second Amendment is crystal fucking clear. Shall not be infringed. No interpretation needed, you moronic cunts. But you ruled restrictions lawful anyway, like in District of Columbia v. Heller, 2008, affirming rights but leaving loopholes for lower courts to exploit, or Bruin, 2022, demanding historical tradition, that you then twist to uphold bans on assault weapons, red flag seizures without due process, or waiting periods. History. History doesn't trump the fucking Constitution. And it sure as shit doesn't prove restrictions are constitutional, you history-misusing pricks. The framers wrote it to arm us against tyranny, not let you play what did 1791 look like, games. If history showed slavery, would that make it okay? Fuck no. The text rules, amendments fix. But you kept ruling for the state, lacking authority, spawning anti-gun programs, and laws that disarm law-abiding folks while criminals thrive. Nonviolent offense. Boom. Lifelong ban. Second-class citizen. Your family can't even have guns nearby due to constructive possession bullshit. This has made America unsafe. MS. 13 raids, rapes, murders, invasions. All possible because nobody can defend themselves or others, you disarming assholes. Violent thugs get black market guns. Innocents who did something stupid get fucked. It's incompetence. Stupid politicians talking slick for votes. But you judges are the most pathetic, sworn to protect the Constitution but committing treason by weakening our nation. Vaccine jabs. You upheld mandates under public health, ignoring 9th Amendment bodily rights. Politics. Gerrymandering, Richo v. Common Cause, 2019, let's rigging flourish. Crime. Soft rulings enable no bail releases, decriminalizing theft. Economy. Commerce Clause stretches birth overreaching agencies like ATF, EPA, crushing us. Your living document, excuse bypasses amendments, aiding enemies of liberty under Article 3, Section 3. And don't think you're off the hook for the financial Armageddon, you banking-enabling bastards. You're neck-deep in the clusterfuck from banking disasters to the government, pissing our tax dollars on foreign handouts without a shred of constitutional warrant. Article 1, Section 8 gives Congress power to coin money, regulate the value thereof, but you've let the Federal Reserve, a quasi-private cartel from 1913, run wild. Rulings like McCulloch v. Maryland, 1819, stretched necessary and proper for national banks, then Reich v. Gonzalez, 2005, under Commerce Clause bullshit let feds meddle everywhere. You green-lit Dodd-Frank Post, 2008, empowering big banks while bailing out too-big-to-fail pricks. Could have axed the Fed as unconstitutional, no explicit warrant, but you deferred to experts, via Chevron, gutted now, thank fuck. Result: inflation from money printing, bubbles, debt traps. Your money's worthless because you won't enforce sound money like gold/silver standards. Foreign aid? Textbook unconstitutional, spending limited to common defense and general welfare of the United States, not Ukraine or whoever. General welfare is domestic, per Madison in Federalist No. 41, but you twisted it in United States v. Butler, 1936, and Helvering v. Davis, 1937, opening floodgates for global giveaways. You uphold aid packages, dodging challenges with political questions, Baker v. Carr, 1962. Trillions to wars while our borders rot. $34 debt, inflation, all your fault for not enforcing enumeration. Taxes. The no-budget scam violates the core. Taxes for debt, defense, welfare, but unlimited is theft. Article 1, Section 9 requires appropriations, implying limits. 16th Amendment allows income taxes, but not blank checks. You fucked it in Brushaber v. Union Pacific, 1916, for progressive taxes, South Dakota v. Dole, 1987, for coercion. No balanced budgets enforced, continuing resolutions forever. Taxes skyrocket for corporate bailouts, foreign bribes, pork, no cap on general welfare. Unlimited taxes equals unlimited government, what the revolution fought. Your treasonous elites protecting the swamp. Enough of this horseshit. We the people must demand abolition. And qualified immunity via legislation like the George Floyd Justice and Policing Act, stalled. But push it, you stalling bastards. Impeach activist judges under Article 2, Section 4. Restore originalism, rights are absolute, not balanced. Amend if needed, but don't let judges do it sub silentio. Boycott the system. Jury nullification when the law is unjust. Arm yourselves with knowledge. Read the Federalist Papers, not your twisted precedents. The revolution started over less. Time to remind you tyrants who's sovereign. You judges are dumb fucking traitors in robes, destroying the Constitution you swore to uphold. We're not sheep. We're the heirs of 1776. Fix this, or face justice.